Council, make your appearances.
Reagan Harrod here on behalf of defendant Don Triplett. David Gibson is also here on behalf of this defendant.
Brandon Tittle on behalf of Jeremy Halton.
Okay.
Your Honor, this motion was brought by Mr. Triplett. This is an amended motion to expunge a lis pendens that is affecting his constitutionally protected homestead. We move specifically under section 12.0071, subparagraph C1, which is that the lis pendens must be supported by an underlying lawsuit, and that the pleadings themselves have to support that real property is involved for the lis pendens to be affected. We're not here today under any of the other subparagraphs that they don't have a probable real property claim. It's just that their pleadings themselves do not give them the right and the relief that they're requesting. I think that the issues have been briefed fairly well by the parties, but the overall precedent in this case is that their real property claim, which is a constructive lien or equitable lien that they're seeking in a homestead, fails as a matter of law. It goes against Texas Supreme Court precedent in Flores, and it goes against Curtis Sharp versus Glover, which is a Dallas Court of Appeals precedent from 1985. Specifically, this case is also directly shares many of the same facts as Countrywide Home Loans versus Howard, which is a case out of the 3rd District, Austin, from 2007. Several issues that are very similar, but just as in that case, the crux of their claim is that investment proceeds were rediverted by Mr. Triplett to make improvements on a homestead and to pay down the note. There is no dispute, no question that the homestead was already in existence, that Mr. Triplett already had title to his homestead. They're saying that after he had acquired title, that some diverted investment proceeds were used to improve and make payments on his homestead. That is more attenuated than what was being examined in Country Home versus Howard, where they say that the crux of the claim against McLean is that she illegally obtained corporate funds and used those funds to buy real property. Under those facts, that court said you can't have a constructive lien or an equitable lien based on clear-cut Supreme Court precedent that says, clever pleading, whenever you're not seeking a direct interest to real property, but are seeking an equitable position in property, you can't do it. The underlying lawsuit has to be about the property. Courts have significant power in equity, but the equity is really only prevailing if the underlying lawsuit is, hey, you stole the property from me by giving me a fraud piece of paper. We're trying to unwind what you shouldn't have been able to acquire otherwise. That the Countrywide Homes case specifically looked at Flores and Moss, and then also distinguished it and looked at case law that opposing counsel is relying on, which predates that precedent, First National Petroleum Corp versus Lloyd, and Teve Holdings versus Jackson. Specifically looked at that case law and said, that's not this case, and it's not prevailing. That in those cases, I did a good job, I believe, in my reply, going through each of those cases and talking about how, even if you were to look at those cases, they're more about the subject matter property than this case is. And I think it's important. Opposing counsel has now filed 2 amended petitions since we filed our motion to expunge lis pendens, because he knows that his original petition just didn't get there under clear-cut precedent. He filed a 2nd amended petition this morning, an hour or less before we were supposed to go on to this hearing. In that, he alleged for the first time that his client is entitled to fee simple title based on a constructive lien or equitable subrogation lien. And I think the timing just really shows that he is concerned that the precedent really does bar him. Countrywide Homes actually even does a pretty good job of looking at relation back and whether you can even amend your lawsuit after the lis pendens is filed, whether or not that's still valid. Because at the time that he filed the original lis pendens, we've gone on almost 3 years since this case was originally filed, and he's now filing an amended petition solely to protect the lis pendens, which is a nullity under clear-cut precedent. Specifically, the Countrywide Home Loans case looked at the relation back doctrine, saying, hey, it's an equitable remedy. You have to construe that tightly, and said that if you're going to be able to amend a pleading at any point, essentially a lis pendens, you can never rule on it. Under Howard's interpretation, any party could hold a piece of real property hostage simply by filing a notice of lis pendens. No one would be able to determine the validity of the lis pendens until after judgment was rendered, because pretrial or trial amendments could retroactively validate the notice of lis pendens. So they specifically declined to use the doctrine of relation back to the lis pendens. Importantly, in one of our pleadings, we specifically said that he's going to amend seeking title to the property. So we would have objected to this pleading as unfair surprise under Texas Rule of Civil Procedure 63, but it's no surprise. We knew that he would make any argument to try and tie up this property. And I think it's a little bit unconvincing that they would take this route an hour before this hearing is called to make a last-minute amendment. But even taking their pleadings, Your Honor, is again telling that the underlying lawsuit is not about this homestead, this specific real property. In their facts section, in their second amended pleading, there are 23 total paragraphs. There is a half paragraph dedicated to any mention whatsoever of the homestead. That is paragraph 29. The crux of the case, all of the facts are about an illegally obtained, alleged, purported investment funds that plaintiff didn't get repaid on and that weren't reinvested into the business. A throwaway half paragraph is said that upon information and belief that these funds were used instead for Mr. Triplett's homestead. That's just not close enough. The nexus is not close enough under clear-cut precedent under Flores, the previous case Moss v. Tennant, which the Texas Supreme Court upheld in Moss, Countrywide Home Loans. And then I included in our filing a case in Ray Chong, which was a recent case out of 2019 from the Court of Appeals from the 14th District in Houston. Again, they went through and looked at Flores, controlling precedent, again, said that Teve Holdings was decided before Flores and should fall. It's not good law. And they specifically say that, let me find, that because the plaintiff
Within the statute, is there any pleading deadline? Like I know there's a lot of case law and summary judgments that say that you have to do a motion to, you have to file an amended petition, usually at least 7 days in advance. Is there any type of deadline within the statute on a motion to expunge lis pendens on when you're supposed to make this determination?
No, Your Honor, not specifically, and I didn't see that much case law, but Countrywide Home Loans looked to the statute, and that's how they got their basis that you can't use the relation back, because they said it wasn't contemplated by the statute itself. But I don't see anything in there. I may have missed it, but I don't see anything that would that has that information that you're requesting. But in Ray Chong, again, they said that they're not seeking to restore real property that was misappropriated from it. Instead, they're seeking an interest in real property to satisfy a judgment. There's no question that Mr. Haltom, the plaintiff here, ever had an interest in the homestead. He didn't have any interest in the actual, appliances or TVs or fixtures, furniture that, was allegedly bought and then incorporated into the property. He's saying he had an interest in funds and that those funds were then, over time upon information belief converted.
All right, let me hear from Mr. Tittle.
Your Honor, I think the issues are boiled down to two distinct issues, and they're somewhat convoluted based on opposing counsel's description just then. One is, did we assert a real property interest? The second issue, which goes into the Curtis Grove case, is whether we can have a lien or constructive trust on a homestead for improvements and not for the purchase of the real property, because they're saying that if the homestead is already in place, then you can't have a constructive trust on a homestead. It has to be for the purchase of the homestead, so the actual cloud of title comes into play. And so we have to look at this under two different prongs. First, did we have a real property interest? And if you go back to even our first amended complaint, not even our amended complaint, we have pled different facts than all the other cases that are cited by opposing counsel. We actually say, unlike these other cases, let me get to it real quick. We have, and we state we have a direct interest in against the property, not a collateral interest. And then if you go to the amended petition, paragraph 123, as a result, Haltom provides notice to any potential purchaser of the property or any interest therein of the existence of this litigation and the allegations that by virtue of this diversion of the investment proceeds to pay for the mortgage payments and the labor, materials, and assets used to improve the property, Haltom asserts a legal and equitable interest in the property. We don't just want an equitable interest, we want a legal interest. And the only thing that can be construed as a legal interest is title. The only thing we didn't do is state it. And that's why they caught on to this. They spent the majority of the reply stating, we didn't ask for title, we just wanted an interest. But we didn't want an equitable interest. We specifically put, and this was in our first pleading, we assert a legal interest. We're not like these other cases where in the constructive trust section of the pleading, we ask for constructive trust to secure the proceeds of the underlying collateral. That's not what our constructive trust says. We do not ask for it simply to secure the proceeds. If you go to our first complaint, we state that we have a
Mr. Tittle, I can't hear you cutting out, I think.
Trying to sign here. Let me go back to the petition. We state, Haltom therefore requests this court impress upon the property a constructive trust to the extent of any and all benefits, improvements, payments, or contributions from the investment proceeds. We're not stating that it's only to secure any proceeds from the sale of this home. And then if you scroll down, when you go to notice of lis pendens, we restate all the facts. And then we state that Haltom asserts a direct interest in and against the property, not a collateral interest. And like I just stated, we seek
Let me ask you
and then if
this.
you go down to the paragraph, go ahead.
Mr. Tittle. So you cite to the TEVE, I guess TEVE and Hughes case. Were those cases specifically overruled by the Texas Supreme Court in the Flores case?
I think that they're factually distinguishable, Your Honor, that even under the Flores case, I think that based on the allegations of our complaint, we still cite a real property interest.
Okay, I don't think that was quite my question, so I probably didn't ask it very well, so let me try again. Did the Flores case specifically overrule the TEVE and the Hughes case?
I mean, I would say potentially, depending on what issue you're talking about, Your Honor.
Did they specifically reference those cases and overrule them? Did they distinguish them, or did they discuss them at all in the Flores case?
I think they were distinguished in that case, Your Honor. Okay. And so, my impression of these cases, Your Honor, is that they look at the facts in the complaint. And if the facts show that they're only seeking a collateral interest in the property, based on what they're citing in their complaint, that it is invalid to have a constructive trust only to secure the proceeds of the collateral. But our complaint, Your Honor, and you can go back to the background sections of these other cases, they're not seeking a legal interest. We're literally getting as close to title, other than not stating title, that you can possibly get. There's really nothing else we can state in our complaint other than asking for title. And that's why we filed the second amended petition this morning, Your Honor, to clarify that when we were asking for legal interest in property, we're asking for title. And that's the only thing we've changed. In the first amended petition, we added background facts to show that upon information and belief, Triplet used a portion of the investment proceeds to pay his monthly mortgage payments. And so based on that, we added an equitable subrogation lien, which would put Haltom in the place of the bank for any mortgage payments that were made. That also was not going to change the underlying basis of our petition, which is legal interest in the property. And then, so the only thing we've done with the second amended petition, like I just said, was to clarify what legal interest means. We haven't changed any of the background facts, but we've asked for legal interest in the property from as long as this case has been open. The Lis Pendens itself does not cite to any first amended or second amended or even the first petition. It merely cites the case, and it states that notice is hereby given that cause number DC 18-01418, style Jeremy Haltom versus Don Triplet, individually DFW Design and Remodeling, was commenced on this first day of February 2018, and the 68 Judicial District Court of Dallas County, Texas, is now pending in such court. The action seeks to establish an interest or a right against real property situated in Collin County, Texas, and it's described as follows. So we establish a right. We're asking for a right against real property. I mean, the only thing we could have added differently in this is to say a right against real property, meaning title. And so all the cases that are cited where the petition was concluded to be valid is if they're seeking title. That's why in their reply, they made sure to clarify that we didn't seek title, that we only sought a equitable interest, and that an equitable interest to secure proceeds is considered a collateral interest and not a real property interest. But here, we have more facts than these other cases where they said it's a collateral interest. We've gone as far as you can go without saying title. But basically, we've said title by asserting a direct right to the real property, a legal interest in the property. That's why we filed our second amended petition to clarify that we are seeking a real property interest. That's why we're different from the other cases cited. And then the part two issue. So that's part one, whether we cited a direct real property interest. And I feel like we've gone over and above that for if you compare us to the other cases that they cite. The other issue is whether we can even assert a constructive trust at all for improvements. So this is different than our pleading standard. So the issue is whether we pled a direct interest, and the second issue is, well, can we even have a constructive trust? Is a constructive trust valid on a homestead for improvements as opposed to buying the property? So those issues are different. And I'm not even sure we can even go forward on that issue today, because I think that goes into more of the evidence. But if we even can go forward based on this argument, or
is that based on Curtis Sharp Custom Homes versus
that's
Lumber?
absolutely the case that we're having analyzed today, Your Honor. They cite to a total of 4 cases in support of this position that you can't have a constructive trust for improvements that were obtained by fraud. And the first few cases that they cite to are federal cases. Let me get to this section. So they cite to Moody and Hastings, both of which have no obviously presidential effect here. They're both providing an eerie guess as to what the Texas Supreme Court would say on the issue. And I want to clarify something. The Texas Supreme Court has never held that you cannot have a constructive trust for improvements obtained by fraud. Texas Supreme Court has never ruled on this issue. It's an issue of first impression. That there's no binding precedent from the Texas Supreme Court. The Curtis Grove case is an appellate decision out of Dallas County. But let's go back. So there's two cases, the federal cases they cite.
Even though Curtis Grove is a appellate decision, I have to follow it if it's at the Dallas Court of Appeals, correct? It's binding on me.
If your honor chooses to accept it as the only case on the issue. Our position is there's a lot of other cases in Texas that actually cite the other way. And in fact, the only case that cites this way is from Dallas County, correct? But there's one from Florida.
But if it's Dallas, I mean, it doesn't matter if all 13 other courts hold the opposite of Dallas Court of Appeals rules one way, then I have to follow the Dallas Court of Appeals over all the other 13 jurisdictions, correct?
I understand. I think this is the issue that we're facing, Your Honor, that we need to preserve our error on appeal, have our objections to evidence, and determine whether, if you're going to follow Curtis Sharp, we need to tee up our arguments as to why, to see what the Texas Supreme Court will do on the issue. And then we'll obviously ask for a stay pending this appeal, because I do think that this is going to, this probably does need to go to the Texas Supreme Court. It's never been ruled on. We have cases in other jurisdictions in Texas that are stating the opposite. Curtis Grove even had a very strong dissenting opinion by Justice Atkins, which I think is completely down the fairway as to what the court should look at in determining whether you can have a homestead protect you from stealing money from someone and use it to put into renovation or improvement work. I don't think Section 50 was at all intended to allow people to do that. Otherwise, everyone would try to steal money from people and then use their homestead to protect it. And I don't think anyone thought that's what homesteads were allowed to do. So if Your Honor wants to rule in favor of Curtis Grove, we would like to go through all of our exhibits, determine whether they're admitted into evidence, have a ruling on the exhibits, preserve our errors for appeal, and then we'll obviously be moving for a stay pending appeal.
Response?
Yes, Your Honor. I think this is a case where the lawyers on the other side have done a clever job of trying to plead out of what is fairly straightforward. They keep saying, and he keeps saying, direct versus collateral. Countrywide Homes, acknowledges that can be a close call, but in that case specifically, which is almost right on point with this one, specifically say that you're too attenuated because the subject matter of the lawsuit isn't about the property. The Supreme Court, I've focused most of my time on the direct versus collateral interest because there is a lot of case law in their Supreme Court precedent, and you can rule under the plain reading of Section 12.0071C1. We don't have to get to Curtis Sharp, although I think that is straightforward. It's Dallas precedent and binding upon this court. No other Supreme Court case has ruled against that. But under the property code 12.0071, they're too attenuated. They keep saying that they're asserting a legal interest and not just a constructive trust equitable one. But in their causes of actions, they have 12. There is no claim for specific performance. There's no claim to quiet title. There's no claim for declaratory interest in the property. Instead, they have two equitable remedies, constructive trust and equitable subrogation lien, where they're trying to impose their money judgment into a real property claim. This is not where someone, had a deed signed by fraud and then is trying to undo that with the court. That is what has been distinguished in past cases. You previously asked opposing counsel if Flores specifically overruled Hughes and Teague. The court did not acknowledge those cases in its short opinion, but it did specifically cite back to Moss v. Tennant. And Moss v. Tennant distinguished from Hughes. And in that case, there was a declaratory action seeking title to the property. And there's a fraud claim, and they traced the proceeds to buy real property. And the court looked at that and said, you can't have a constructive trust in that situation, even when you trace the funds. So the Moss v. Tennant case, which the Supreme Court specifically upheld, goes way further than this case. This case is way more attenuated as to is the property at issue in this case.
Okay. All right. This is helpful, guys. I'm going to try to get you a decision within the next 3 weeks. Okay.
Thank you, Your Honor.
Did you freeze, Mr. Harrod? It looks like you froze.
Oh, but Your Honor, can we have, I mean, as far as preserving our issues on appeal, can we go through our exhibits to determine whether they're going to object to any of them? We'd like to introduce all of our exhibits that are referenced in our response, plus we would like to move to introduce the second amended petition into evidence as, I think, Exhibit G.
Any objection to A through G?
Could not care less, Judge.
All right, A through G are admitted. Okay, guys, we got to get to the next one. You guys be safe, okay?
Thanks, Judge. Take care.
Thank you.
Thank
Anyone here on Sherwood v. Palomino Continuing Care Centers?
Yes, Your Honor. This is Alexis Nicole Andres for the plaintiff.
Okay. And who's here for the defendant? Anyone here for, is it 10:30? Is it 10 o'clock? Yeah, it's past 11. So is anyone else here on the Sherwood case? Okay. So as I recall, this case is a scheduling conference, correct?
Yes, Your Honor.
Okay.
Just need to get a trial date and get some dates put in place.
Okay. When would you like to set this for trial?
I am thinking April of 22.
Let me just take a look real quick. Actually, you know what? It's currently set in July. Remind me again, why did we set this for a scheduling conference?
Well, they've basically, the other side has refused to comply with discovery, and I've had to file a couple of motion to compels, Your Honor. And so
Okay.
not a lot has been done. I haven't even deposed their administrator or their director of nursing. It's a healthcare liability claim against a nursing home.
Okay.
So finally, I've got what I think are the tools to carry forward.
Okay.
Whenever the court would like to set it, I will try to be
Well,
ready.
it's currently set in July. I'm a little confused why, and maybe there's a reason, I just don't recall. So what did I say at the last hearing about this?
Well, they filed a motion for summary judgment, a no evidence motion for summary judgment, based upon,
And I denied
Yeah.
it.
yes, you denied it.
And then
And then
did
set the
I
schedule.
tell you guys this was going to be set for a scheduling conference to reset this?
Yes, you did.
Okay. Do you want to see if you can get Mr. Ziegler on the line and see if maybe we can chat with him about scheduling? I hate to do this without him.
I don't know if I'll be able to get Mr. Ziegler, but his associate, Rob Skills, I have his number. I could call.
Okay, yeah, why don't you do that? Just go and put yourself on mute and we'll just make sure we have two more hearings after you that I'm aware of. It looks like there may be more than two. But why don't you see if you can get him on the line and we can talk about trial settings. Okay?
Okay, thank you so much.
Thank you. Is there anyone here on the name change involving Angela Downs? Anyone here on that case?
Good morning, Judge. Angela Downs is here for the petitioner,
Okay.
and student attorney Corey Powell is here as well as our client.
Great. Let me just get to this real quick. Oh, huh.
And Your Honor, if I may, is there a way to perhaps proceed with this matter in a breakout room or?
Do you want, so these are all interns. Do you want me to do this
Oh, if
without
they're,
the interns?
oh, no. If they're all interns, I just wasn't sure if they were attorneys or, kind of who was among us.
Let me see. We have a Mr. Leidy who's here, and Mr. Powell is your student. Did you say he's your?
Mr. Powell is our student attorney. Yes, sir.
I'm not sure why Mr. Kingray is here. Mr. Kingray, why are you here?
I'm on the Amanda Bailey hearing. I'm filling in for Dan Morales this morning.
Ah, okay. And then Aveline Mason, who's
That's our client, Your Honor. Yes, sir.
Okay.
She's
So the only two people who are not, and then Miss Alexis is here. I don't remember her last name, and she's the one I just spoke to. It might be easier for us to go to a breakout room just because I'm not sure exactly who all's here. So let's go ahead and see if I can put you guys all in a breakout room.
okay. Thank you, Your Honor. I very much appreciate that.
No problem. Mm-hmm. Yes, please. I have a lot of interns today. Nancy, I'm going to leave you in the regular courtroom, okay? Okay. I am.
Judge, you're wanting me in the breakout room?
All right, did the other side show up on the Sherwood case? Maybe we can- are both-
Yes, Your Honor, I sent him the link.
Is that Mr. Skeels?
I sent counsel the link. I'm not sure if he's on yet.
Is that Mr. Skeels?
Yes.
Okay. All right, he's having issues with his audio. Are both sides here on the Bailey case?
Yes, Your Honor.
All right, so let's go ahead and hear your continuance.
Yes, sir, Your Honor. This is a case in which the defendant filed their answer on July 23rd of 2020. Since that time, we have taken depositions and looked at property and are actually engaged in preliminary settlement negotiations. The parties asked for a continuance for my trial setting, I believe of next week, June 15th. It's agreed upon motion, Your Honor.
Is this a jury or non-jury?
This is a jury case.
Let me take a look at it. Okay. And how much time do you need?
It's really dependent upon the courts. Actually, I was looking at my trial schedule. February 2022 would work well for my trial schedule. I have not confirmed that with Mr. Kingery, though.
I'm sure we can make it work.
Okay, let me take a look. All right, so February, let's look at dates. The 1st, the 8th, the 15th, or the 22nd.
The 22nd would work better. I have cases set the first 2 weeks in February, but none on that date, Your Honor.
Okay, Mr. Kingery?
That date works fine for us, Your Honor.
Okay. All right, so we'll set this for trial on February 22nd. Okay, I'm trying to print this. There you go. Can you grab Rhonda for me? I need her to print out this order. It's not printing out right now. Anything else, guys?
No, Your Honor.
That's all.
All right, you guys be safe, okay?
May we please be excused?
You may.
Thank you.
Mr. Skeels, are you there?
Yes, Your Honor. I apologize for that. I switched firms and I think it went to my old email address. It doesn't
Okay.
exist.
We were talking about resetting this case, and I wanted to make sure you were part of that discussion. Are you opposed to the reset?
No, I'm not opposed at this point. We filed a summary judgment and that was denied. So yeah, we're fine with setting it.
When I think, and I'm sorry, your last name isn't on there. I don't know your last name, ma'am. What is your last name?
It's Andres, Ondris, Your Honor.
I think you said Andres. I apologize if I'm misstating it. Miss Andres, I think you had said April. Is that right?
Yes.
What are your thoughts about that, Mr. Skeels?
April looks, I'm looking at my printed out calendar and April, the first half of April would be best for me.
How does April 5th sound to everyone?
Sounds wonderful.
Okay, anything else, guys?
That'll do it, Your Honor. I apologize for my confusion there.
That's okay. You guys be safe, all right? You are excused. We'll set this for trial on April 5th.